my point. One is that decriminalizing homosexual relationships and other non-harmful activities is linked to the idea of being equal citizens under the Constitution of India, that all of us have an equal claim to morality, and that the state or a group or a majority cannot say that one is less moral than the other. The second is a claim that criminal law should be tethered to ideas of reason, to the ideas of science, to the ideas of harm, and not to the idea of disgust and revulsion against minority citizens. And third, that independent and principled judicial process can lead to the protection of fundamental rights. Make this conversation more real, I will now open the text of the judgment and start from the very beginning. I'm not sure if the font is visible for all of you, but we will work with it. So the judgment was handed out, as I said, on the 2nd of July, 2009. The case was litigated by Naz Foundation, which is an NGO that works on the prevention as well as control of HIV virus, which is a very big problem amongst men who have sex with men and other members of the LGBT community. The respondents in the case were the government of NCT of Delhi, but also the Union of India. Interestingly, the Union of India had two diametrically opposite representations in this case. One was the representation by Mr. P.P. Malhotra on behalf of the Ministry of Home Affairs, which opposed the decriminalization of homosexuality. And the second was representation by the National AIDS Control Organization, which supported the decriminalization of homosexuality. There was also a group of concerned citizens, including by someone we all like and we know, Arvind Narayan, who represented Voices Against 377 and did a lot of heavy lifting in terms of marshalling international material, domestic material against this law and showing how it was really an affront to human dignity. There were also independent citizens who opposed the decriminalization because they said that decriminalizing this law will mean that a lot of children will become unsafe, and there is a very sensitive issue of child sexual abuse as well as abuse of women by unnatural means. And that will become very clear to us when we read through the judgment in greater detail. What was the case really about? It was about Section 377 of the Indian Penal Code of the 1860. This law, which was headed as unnatural offenses, criminalized consensual sexual acts between adults in private. And it was a case of the petitioners that it violated Article 14, 15, 19, and 21 of the Constitution of India. Now, where did this law come from? Because in India, the written legal tradition only started with the British. We borrowed this law amongst a lot of other dignity affront acts from the Britain. And it was in the medieval ages that there was something called the law of sodomy, and this sodomized who were accused of having sex within the same gender were burnt alive. It was something that became the Buggery Law of 1563, which was enacted by Queen Elizabeth. And soon after, or maybe 3 decades later, in 1861, the Indian Penal Code by the infamous Lord Macaulay, including this as a crime in the Indian law. So Section 377, the text itself read that whoever voluntarily has carnal intercourse against the order of nature with any man, woman, or animal shall be punished with imprisonment for life and with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. This basically means that if there was a consensual sexual activity which was not traditionally penal vaginal in nature, which was between maybe two men or two women or anything against the norm, then the persons who are found conducting those activities could be jailed for a period of 10 years. And as those who are familiar with law would know, that 10 years is a very long sentence in Indian law and is reserved for very serious offenses. There was a serious debate in the court whether this was actually something that was causing any harm on the ground, because the government said that we are not really enforcing this law. There are very few prosecutions, and this is just something that is affecting a very loud minority of civil society. They also said that in other countries there has been a decriminalization of homosexuality, but that is where those countries have the society in those countries has become ready and willing, and therefore till the time society does not become ready and willing, we should continue to suffer um, under illegal laws. On the other hand, the another arm of government, as I mentioned, the NACO, said that because of this criminalization, it was harder for the NACO to prevent AIDS and to supply information and to enable citizens to take decisions for protecting their health care. But very interestingly, the civil society group of Voices Against 377 was able to puncture the narrative that there was no real impact on citizens because of this law. They referred to several incidents, including the Bangalore incident of 2004, where a eunuch or a hijra or a transgender person was tortured in a public space. Then they were tortured in the police custody. There were also other instances where it was found that a gay man was picked up from a bus stand at 10 p.m. by the police who accused him of being a homosexual. He was physically assaulted with wooden sticks, taken to the police post where he was subjected to sexual and degrading abusive language. During the incarceration in the police post over the night, 4 policemen allegedly actually raped and sexually abused him, including forcing him to have oral and anal sex. These factual evidence was core to striking down this illegal law and to show that this was not just some fictitious claims the of the uh, of the civil society. And now I come back to my presentation after having given you this background and try to go to the first claim that I was trying to make, which is that this was a case not just about decriminalization, but it was a case about equal citizenship. The judgment itself read that if there is one constitutional tenet that can be said to be underlying theme of the Constitution, it is inclusiveness. It is the recognition of equality which will foster dignity of individual. It referred to the objective resolution that was introduced by Jawaharlal Nehru in 1946, which said that the spirit was to liberate all Indian citizens from being judged by foreign standards, by being judged by unfair standards. And this was really the 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 spirit of the whole judgment. It is worth it to read a few paragraphs from the concluding section to make this emotion and this spirit very apparent. It was before declared when the court declared that section 377, insofar it criminalizes consensual sexual acts in private, is violative of the Constitution. It said that this is true, but at the same time, non-vaginal sex and penile non-vaginal sex involving minors will continue to be a crime. The court said that inclusiveness in Indian society has been traditionally displayed literally in every aspect of life and is manifest in recognizing a role in society for everyone. In the court very adroitly also mentioned that Indian society was different from Western society, which has for a long time criminalized these activities. And to make good on its point, it cited whom? The government's own law officers, making its case before the UN Human Rights Council. And I will quickly be reading from that portion. Yes, so the UN Solicitor, the India's Solicitor General before the United Nations Human Rights Council had said, around the early 19th century, you probably know that in England they frowned on homosexuality, and therefore there are historical reports that various people came to India to take advantage of its more liberal atmosphere with regard to different kinds of sexual conduct. He goes on to then mention the law drafted by Lord Macaulay, which said that that these sexual activities are against the order of nature. Then he makes a claim that in India we didn't have any this concept of something being against the order of nature. It was essentially a Western concept, which has remained over the years. Now, homosexuality as such is not defined in the Indian Penal Code, and it will be a matter of great argument whether it is against the order of nature. It's interesting to note that there was a time when India said globally that homophobia was a Western concept, and it is now that some of the people in our government and in politics say that being LGBT, of having alternative sexuality and gender, is a Western concept. So it's very interesting to point the government to its own stance in global forums and to say that, okay, if it is your idea that India as a civilization has been accepting and accommodating more than the West, then maybe we should prove it out in how our laws are. And a great example of that remains the 2026 Transgender Persons Amendment Act, which has really put up a very colonial, very Western notion of biological essentialism to deny trans people of their right to identify themselves. The second claim that I wanted to make was that the Constitution cares about public interest, the Constitution cares about reason, the Constitution cares about science, and it does not care as much about disgust. The court went on to say that public morality, which is a ground under the Indian Constitution, is a shifting phenomena, whereas only constitutional morality can justify certain coercion. It goes on to cite the UK report on homosexual relations, which said that revulsion at the unnatural or sinful or disgusting sexual activities is no valid basis for criminal law. It said that constitutional morality must outweigh majority morality, even if the majoritarian morality is held on by a majority of citizens. Further, it makes the claim that Article 14 of the Indian Constitution requires that any classification between citizens to be made on the basis of intelligible differentia. Therefore, there should be a rational nexus, and that equality is an antithetical value to arbitrariness. Once consenting adults are removed, Section 377 has no rational nexus to any legitimate aim. Here, again, the court flipped the argument of the government that it was not really criminalizing and prosecuting LGBT citizens by saying that if you are not criminalizing them, then this law has no rational basis with its aim of preventing unnatural sexual conduct. Finally, a very important advance was made in Indian equality law, which is that when Article 15 says that no one shall be discriminated against on the basis of sex, it includes discrimination against people on the basis of sexual orientation. And the court did a very elaborate use of the international human rights law standards, international human rights developments, which again is a far cry from the Indian judicial discourse and the legal discourse today, where we are moving far away from the international human rights conversation. Again, I will take this opportunity to read through the judgment to para 57. And it's 59. Here, the court said that popular morality is distinct from constitutional morality, which is derived from constitutional values. If there is any type of morality that shall pass the test of compelling state interest, which is valid under the Constitution, it shall have to be a constitutional morality and not public morality. The Constitution of India recognizes, protects, and celebrates diversity. To stigmatize or to criminalize homosexuals only on account of their sexual orientation shall be against constitutional morality. Then it goes on to cite a lot of South African, Canadian, and other precedents to ultimately cite a very important US precedent where in 2003 in Lawrence v. Texas, the US Supreme Court struck down the decriminalization of homosexuality and said that moral conviction or instinctive feeling, however strong, is not a valid basis for overriding the individual's privacy and for bringing within the ambit of criminal law private sexual behavior of any kind. to preserve public order and decency, to protect the citizen from what is offensive and injurious, and to provide sufficient safeguards against exploitation and corruption of others, particularly those who are especially vulnerable because they are young, meek, or weak, but not to intervene. But that does not mean you can intervene in the private life of citizens or to seek to enforce any particular pattern of behavior. This again comes from the idea that you have to respect the privacy, the liberty of citizens. And this passage is very interesting because it is extracted from Justice Kennedy's opinion in Lawrence v. Texas. And Justice Kennedy was greatly influenced by a rather conservative scholar called Frederick Hayek, who said that individuals' private lives should be left undisturbed and Indian individuals should be allowed to live in a sphere of spontaneous order. Interestingly, the court goes on to cite a Law Commission of India report of 172, which had recommended a wholesale overhaul of the rape laws in India, and which had said that this provision should exclude the consensual act within adults. I already read the statement of the UN at the UN by the Solicitor General, but I should now read the extract from an opinion of Justice Michael Kirby, who was probably in the history of the world the first openly gay Constitutional Court justice, who had expressed that these laws had the colonial legacy of Macaulay, Stephen, and Griffith, and that these are wrong for various reasons, but most importantly, because they are wrong in legal principle, because they exceed the proper ambit and function of criminal law in society. They are also wrong because they fly in the face of modern scientific knowledge about incidence and variety of human sexuality, and wrong because they put a cohort of citizens into a position of stigma and shame that makes it hard to reach them with vital messages about safe sexual conduct, essential in the age of HIV/AIDS. Finally, it is important to mention the British report, which said that moral indignation, howsoever strong, is not a valid basis for overriding individuals' fundamental rights of dignity and privacy. And having said so much about my second claim, I move on to my third claim, which is that judicial independence is very critical to protecting rights. And it might come across as a very obvious statement, but it is very important to stress on it today. Before the Delhi High Court in 2009, the government of India's case was that this was a law enacted by the parliament, maybe by the colonial parliament, but never amended ever since. Therefore, it reflects the wisdom of the political classes. It can never be struck down because it is presumed to be valid, and the judiciary under the Indian Constitution does not have the right to strike down a statutory law. And the court said, you know what, it's additional Solicitor General, your understanding of the Indian Constitution is fundamentally wrong. We, as an independent judiciary deriving its strength from a written constitution, which has Article 13, that anything that is inconsistent with fundamental rights shall not remain valid law, have the power and the duty, more importantly, the duty to protect Indian citizens and to protect the Indian citizens from the creeping authoritarianism and invalid exercise of legislative power by the state. The court said that rights do not depend on head count. When elected branches default or pander, individual courts apply principle. This is constitutionalism. Indian constitutional law does not permit the statutory criminal law to be held captive by the popular misconceptions of who the LGBT citizens are. Therefore, the court made it clear that this was a valid exercise of its constitutional power, and the judicial independence is fundamental to democracy. It is an instance of democracy. It is not against democracy. And it is important to stress this point because day in and day out, we have the current majoritarian authoritarian government stress upon its wisdom to make fundamental changes to our constitution, but to also expand the scope of criminal activity without allowing or without tolerating an independent judicial process. And as citizens who are concerned and jealous about our liberties, it is very important that we take them very seriously. And The proof of the pudding is in the eating. Since 2009, we saw the Supreme Court fail us in 2013 when it reversed the Naz judgment on appeal. That appeal was filed by a citizen who was not a party before the Delhi High Court, who was just an astrologer, who had no real locus in that case. And the court said that these are rights of a minuscule minority, and the parliament has the real privilege to change this law. But then what happened? Another petition was filed in 2016, which said that this judgment is wrong. And a three-judge bench of the Supreme Court referred the matter to five judges who ultimately decriminalized homosexuality in the year 2018 on 6th of September. And at that stage, the government did not defend the law. The government said it left the law and its operation to the wisdom of the courts. So mark that it took 9 years for the government to surrender from its mantle of wisdom of the public representatives to the wisdom of the court. Now that I have made my three basic points, I will quickly go to telling a story about the US and how a lot of progress has been made in the US context when it comes to the rights of LGBT citizens. The first instance of decriminalization happened in 2003 by the Supreme Court of the US, which preceded India's definitive decriminalization by 15 years. And within 12 years of that, same-sex marriage was allowed and legalized to a 2015 judgment of Obergefell versus Hodges. One would think that how can a society take only 12 years to move from a place of criminalizing its citizens for just having sexual encounters to a place where those sexual encounters are recognized and the love and the humanity of those citizens are recognized as valid relations. And that the answer to that often comes into the bipartisan and widespread understanding that LGBT citizens deserve rights. LGBT citizens deserve to live in the sphere of spontaneous order and liberty. And it also required a lot of Republicans, the people on the right, people on the conservative side of politics, to acknowledge that these rights are valid, and which is why that even when the US Supreme Court had a sizable conservative presence, there was the Obergefell versus Hodges case, and same-sex marriage was legalized in virtually all of the entire country. And this is probably a call for those who care for LGBT rights in India to take the political turn to convince and persuade our citizens to say that just like they take care of their religious freedom, just like they take care of their other freedoms to live their life, to move from Delhi to Bangalore, Bangalore to Manipur, similarly, the freedom to live with the person of their choice is a fundamental freedom. And that it takes me back to the conservative scholar Hayek, who said that state should not commandeer. State should allow there to be a rule of law. State should ensure that people do not commit violence against each other. So transgender people should not be at the sufferance of violence and bullying in their families and in their schools. State should protect them. State should also not tell how a family and how a society should be framed. A family can have 3 fathers or 2 men, or a man and a woman. They need not be married. And thirdly, that even when it comes to transgender people's rights, when it comes to having difficult moral conversations, we should be having those moral conversations and connecting it with the other rights that our fellow citizens hold dear. Now that I have made all 3 of my claims, I'll end the presentation, and I think we can now have a more open conversation. And thanks again for listening to me.